Good evening, everyone, esteemed guests, distinguished panelists, and our honorable EC members and dear students. I welcome you to this insightful panel discussion on the topic of very much paramount importance in international law, the International Court of Justice and public interest litigation. The ICJ, as the principal judicial organ of the United Nations, has undergone a transformative journey in response to the changing dynamics of the international legal landscape. Originally tasked with settling disputes exclusively between member states, the ICJ's purview has expanded to encompass a broader sense of global responsibility. This evolution is encapsulated in the emergence of public interest litigation, a groundbreaking concept that introduces a third-party dimension to international legal proceedings. Unlike the traditional approach limited to direct parties, PIL allows for legal action to be taken in the wider interest of the international community. In essence, PIL and ICJ contexts mirror its domestic counterpart by focusing on safeguarding the collective interests that transcends individual states' concerns. This shift acknowledges the existence of erga omnes obligations, which are duties owed by states not just to one another but to global community as a whole. These obligations include critical issues such as preventing genocide, slavery, and piracy. The recent landmark cases such as Gambia versus Myanmar and South Africa versus Israel stands as pivotal moments in the evolution of international law. These cases mark a turning point solidifying the right to file public interest litigation under the erga omnes principle, shattering the limitations of nationality and treaty membership. As a result, a new era of expanded accountability has dawned, allowing states, particularly those in Global South, for seeking justice for international violations. So today we embark on a journey of exploration and analysis, delving into the implications and prospects of this transformative shift in international law. I invite our esteemed panelists to share their insights and perspectives on the intersection of ICJ and public interest litigation. I would now like to invite our Secretary General, Sri Narendra Singh Sir, to give the welcome address and introduce the panel.
Good afternoon, everyone. I welcome you all to today's discussion on the public interest litigation and the international justice. And I have the honor to welcome our distinguished panelists today. Mr. A.K. Ganguly, Senior Advocate of the Supreme Court of India, also a former Vice President of the Society. Dr. M. Gandhi, Vice President of the Society, formerly a Joint Secretary in the Ministry of External Affairs, and he has also been a professor and dean of different universities. Dr. G.V. Rao, Vice President of the Indian Society of International Law and Senior Advocate in the Supreme Court of India. And of course, we have our distinguished President of the Indian Society of International Law, Shri P.H. Parekh, with whose support, and we have organized this session here today on this very important topic of very topical relevance. As you all are aware, the International Court of Justice is the principal judicial organ of the United Nations. And this is one of the methods of peaceful settlement of disputes mentioned in Article 33 of the UN Charter, which requires states to settle their disputes through peaceful means. Although it does not mandate any particular method, as long as they choose to settle the dispute through peaceful methods. Essentially, the ICJ has jurisdiction over disputes between states parties. private parties cannot approach the court. Now, international law, as you are well aware, is based on the choice of states. States can choose to ratify conventions, and they can also choose not to ratify. States can choose the International Court of Justice as a forum for settling their disputes through specific conventions and treaties, or by filing a general acceptance of jurisdiction. States can also agree to approach the ICJ by way of special agreements between the parties to a dispute. Or the ICJ can also have jurisdiction through another process known as the forum propagatum, where if a state files a dispute before the ICJ and the respondent does not oppose it but agrees to the jurisdiction, then the court can proceed and hear the dispute. Now, these are all matters where there is directly a dispute between the parties. But here now, we are today seeing a different situation, where the parties who are before the court do not themselves directly have any dispute between them. Earlier, nationality has been considered by the ICJ as the basis for the state to take up a dispute, like in the Nottebohm case, the Barcelona traction case, and later the essence of whether the party who was directly concerned was before the court or not was also an issue, depending on which the court would take up a matter. Like in the monetary gold case, which concerned the removal of monetary gold from Italy to Germany during World War II. This gold was later recovered in Germany after the war, and it was found that it belonged to Albania. Now, different claims are made on these gold reserves. Great Britain claimed that this gold should be used to satisfy an earlier decision of the ICJ that they were entitled to compensation from Albania. Others also tried to claim it. Italy also claimed and went to the ICJ to make a claim. The ICJ held that Albania was an essential party to the case, and if Albania was not present, the court did not take up the matter. So the essential requirement here was that the one party whose presence was required had not come before the court. In recent years, there has been a shift now, where states have taken up a case and gone to the ICJ in a matter where they are not directly concerned with the dispute. For example, in the case of Gambia versus Myanmar, Gambia approached the ICJ complaining that Myanmar was in violation of the Genocide Convention. And this was done after a decision by the OIC, that is the Organization of Islamic Countries, which requested Gambia to take the matter to the ICJ. And the ICJ took up the dispute. Even though between Gambia and Myanmar there was no direct dispute, but the ICJ held that both of them were parties to the Genocide Convention, and Gambia did have an interest in ensuring that the obligations of states parties under this convention were adhered to and implemented by Myanmar. Similarly, now more recently, we have the situation of South Africa, which has approached the ICJ against actions by Israel in Palestine. Now, this case presents some features which are not present in the earlier, in the case of Myanmar and Gambia. Because here we also have another party, that is Palestine, where the actions in violation of the Genocide Convention are alleged to be taking place. And Palestine is not before the court. So this raises a different aspect where, because if ICJ gives a judgment, the decision is binding on the parties to the dispute. That means it is binding on South Africa and it is binding on Israel. But what about Palestine? So I think this is one issue which I would think the panelists will take up, and I hope other important aspects also would be raised during our discussion. And I would now invite our first panelist, A.K. Ganguly, to address the...
Thank you. Am I audible? Thank you, Narendra Singh, for the introduction to the topic. But let me first compliment all of you for having chosen a title to the topic for today's discussion. The title is Public Interest Litigation in the International Court of Justice. There is no such concept actually, like public interest litigation, but somebody has coined it, and I compliment. Maybe Narendra Singh? Narendra Singh?
Not my origin.
I do not know, but anyway, whosoever it is, compliment goes to...
There are a lot of research work has been
Good,
done.
very good, Gandhi. I could see your presence very much. So we acknowledge.
Topic.
We only acknowledge, I acknowledge, rather on behalf of all, that it is a very good thought that is occurred. Now, why have you chosen? I really don't know why you were chosen. But what appears to me to be a concept which is now seen at home for several decades now. In India, as you know, this concept evolved some about 3 to 4 decades before, with some activist judges, first in the High Court and then in the Supreme Court, relaxing the rule of standing. That's the fundamental feature for initiation of any litigation in any forum, any judicial forum. Then a person who seeks to initiate a litigation has to have what is called the standing, the requisite standing. So if someone has filed a petition, he must justify what is his standing, what is his legal right to maintain the proceedings before the court. Now, anybody who is affected has a right to move any court and seek vindication of his rights and vindication of the obligations of the opposite parties, whosoever they may be, private or public concerns. But then the question eventually came up to the court in a different way, like through the episcopal jurisdiction, a coinage by Justice Krishna, that somebody who is underprivileged and who has no access to justice at all, he can't hire a lawyer, he can't have access to the court by means of reaching the court. So what he does is somebody else who feels that this underprivileged person needs the protection of the law because he has a right to the protection. So then someone else moves the petition on the law in the larger interest of the people. That's how the concept developed in the domestic world. But this is totally unknown in the realm of international law, as Mr. Jesse has explained to you. Because who are members of the United Nations and the institutions? It is only the states. So a state affected by an action of another state would definitely have a right to move the judicial forum. It could be ICJ or any other forum for that matter. You also have, in fact, the building in which ICJ is located is the oldest institution in the world which had introduced the process of adjudication, that is the PCA, 1907 was founded. So it has been built. And that's why, Mr. Singh pointed out to you, the mandate of the one of the articles in the charter is that you must peacefully settle your disputes first. This is one of the methods of doing it, is mediation, arbitration, etc., etc. And PCA plays a very, very important role in that very building where on one side of the building you have the ICJ. Now, why I compliment it is that this is now seems to be a concept that slowly creeping into the international law as well. It's not exactly the same rule as the public interest litigation, but it is definitely a kind of a relaxation of the rule of standing. Number one. Two, and the nature of the dispute that a party has chosen to bring before the forum, that is the ICJ, whether that is a dispute which could be adjudicated upon by the ICJ at the instance of the parties who has moved the court. That's the vital question. So two examples which Mr. Singh gave to you, the Rohingyas, they were Myanmar, Gambia was Myanmar. Now, Gambia had nothing to do with the Rohingyas at all. But they complained that Myanmar was not discharging its obligations under the Genocide Convention. Every state who is a party to the convention has an obligation to abide by the mandates of that convention and to follow and give requisite protection. Now, Myanmar failed to do so, according to Gambia, and therefore they brought in an action for protection of the rights of the Rohingyas who are part of Myanmar. They are the citizens of Myanmar, they are not citizens of Gambia. And as you know, when we go through the details of the judgment, there was a kind of, an insinuation in the sense, it was suggested possibly that Gambia had some other, reason to initiate these proceedings. Some other religious organization were possibly instrumental in putting up Gambia at the front, because they cannot come on their own. A religious body has no locus. It's only a state who can bring an action before the ICJ. So it's a front. Gambia was acting as a front. The court dismissed that because eventually the court found out that, look, any party, this is very important, any state which is a party or signatory to the Genocide Convention is entitled to bring an action before the court complaining about inaction or non-compliance with obligations by another state. This is how the court expanded the scope of standing and also the scope of the nature of the dispute. This is not state versus state, no. A state is complaining, like the dispute is what is happening within a particular country, obligation of that country vis-a-vis their own citizens. That was the case of Gambia versus Menon. Now the recent case of Israel versus South Africa versus Israel is also very interesting, because this now opens up another dimension. The dimension is the persons who are victims are those Palestinians who are residing in the Gaza Strip, in a different territory. They are not in Israel. It was actually a battle between the Israel on the one hand and the Palestinians in Gaza. First, Israel says that they were, the offender, because they killed something like about 1,200 population within Israel, and therefore this was a countermeasure which they had to take to stop the Palestinians from continuing with what they were doing. They were complaining rather the genocide is by them, by the Palestinians in Gaza. That is, even the ICJ also accepts that yes, there had been some of this incident, and certainly nobody can counter that. So that's an action for which Palestinian in Gaza had to be condemned. But that does not give a license to Israel to what they were doing. Any number of reports and most significantly observations made by the Secretary General and many other high-profile authorities at the United Nations confirming the acts of Israel that resulted in a kind of a genocide. That is how the court accepted the standing of South Africa to initiate an action. And subject matter of dispute being infraction of the obligations under the Genocide Act was already ruled by the court in the Menon case. That's a subject matter which is well within the competence of the ICJ to determine and to decide. So there was subject matter of dispute. There was no dispute. There was no occasion for a change because that was already ruled properly by this. What was now to be decided is, can South Africa bring out a company when the affected state is not before this ICJ? The state who is affected is the Palestinian. They did not come before. And a very interesting question is, what happens if they were to disown the action by South Africa, or for that matter, so many other states join, large number of states, Canada, UK, all countries have joined subsequently in the very same cause. So that may be a very interesting question which at an appropriate time one would go into. So far the question hasn't arisen, so one need not go into. And we should not also assume that the ICJ by this decision has rendered any finality to its thoughts. It has only come to two conclusions on vis-a-vis a few aspects, like, yes, South Africa has a standing, first thing, to maintain the proceedings. Second, the subject matter of complaint is a dispute which ICJ is competent to adjudicate. Third, it is complaining about the obligations under the Genocide Convention required to be performed by Israel, and which is also enforceable and subject matter of an adjudication. That's also subject matter which could be reported, and a legitimate dispute within the jurisdiction of the ICJ. This is all that the court has said. And when the court was asked to issue the interim measures, it has issued certain interim measures, but you will recall one salutary feature being absent in that order, that asking Israel to cease hostilities. Or there is no such direction. The direction is to ensure that people in Gaza are not subjected to what they were being put to by Israel. So prevent your military forces from committing such acts. This is how it is being put. It's not a question of cessation of a war as such. He hasn't done it because they have not reached that stage. And it was not necessary for the court to record a finding at this stage, at the interim stage, to that effect. They have not decided any of that. They only taken a cause that yes, there is a standing as I told you, and there is a cause. There is a prima facie infraction of the Genocide Convention by Israel, and therefore it is cognizable, it is enforceable at the instance of another party state. And since South Africa is a party to the Genocide Convention, they are indebted. You would also notice that the statutes of the ICJ provides that whenever there is any question of interpretation, serious interpretation of convention are involved, including treaty, etc., but convention is involved, all parties to the convention automatically get a right to intervene. All parties. So here, instead of, a lot of other parties have intervened, like Canada, UK, etc. If they have right to intervene, they have might as well a right to initiate the proceedings on their own. So that is how the question of locus standi has been, or the standing has been relaxed. And this is a very good development. It is a notch ahead of what was decided in the Myanmar peace. But there it was only a question as to whether Myanmar to protect its citizens or not, which every signatory to the convention has a duty in their own country. But here it is a further step that you are going on to another country where that country is not completed. And still the court feels, yes, the third party is justified being a signatory to the convention to initiate such proceedings. So these are my introductory comments. We will go on hearing other comments.
Request Dr. Gandhi.
Yes, Mr. Gandhi, please.
It's 10 to 12 minutes.
Yeah. Thank you very much for giving the floor. I think an interesting introduction has been given by the Secretary General as well as good friend, Senior Advocate Sri A.K. Kalkudi. The point here is those who are exposed to international law are little exposed to even international law about the court procedure and other things. They know that standing of the party is important. They must have interest in the case. But the standing, they have been talked about the standing. The standing can be always found because court has every authority to find such jurisdiction. It's all happened originally in Barcelona attractions case. That erga omnes obligation is an obligation that goes to every state, to the internal community. It also is a kind of an obligation. So on that basis, if you see that from Barcelona onwards, there are cases like Southwest Africa, Belgium versus Senegal, Gambia versus Myanmar, South Africa versus Israel, and the latest one that Israel versus, South Africa versus Israel. So you can find all these things very clearly that there must be some basis. Here the locus standi has been in fact expanded in the Indian condition because of your judicial system and the constitutional rights. So it has linked to some kind of a substantive rights also. It is not just floating over the air. But as such, if you see that the international system, you must have some basis, because there are two important things we have to see, and which are all very peculiar to international system, and they have alluded also on that. First thing is whether there is a dispute or not. The two injured parties are coming on, not first thing, and they must have a dispute. If they don't have a dispute, and the court will not have jurisdiction. And they have not consented for that to be, decided by the court will not take jurisdiction. So there must be some basis for this kind of the relaxation of a locus standi, especially from the perspective of actio populans, what we say that the public interest litigation. Strictly speaking, it is not a public, it is not a kind of the PAL that we have in India. It is the relaxation of a kind of, again, the entitlement of a party to oppose other party, or entitlement of the party to take a matter before the international tribunal, which was on the basis of the consent given earlier. So they have given a consent in the treaty. That's why, basically all the cases you can find that. You can find in most of the cases it comes the Genocide Convention. When the Genocide Convention, their consent has been given by all parties. Then another case I said that Belgium versus Senegal, that case is about that prohibition to, prohibition of tort, prohibition of, the commission of torture, the torture convention. So the prohibition of torture, see, these are all, emerging because it is touching on the erga omnes obligation. because it shocks the conscience of the world. This is happening, something like that. And whether, whether you consent it or not, whether we will involve otherwise or not, that should be taken on the basis of consent already given. So, the court assumes that as if the consent is already given by the parties. Not necessary that you have to give consent. Because it was, very clearly stated that, two ways, the jurisdiction can be approached. One is, you have already given a consent. The second is, of course, send a notice and you did not respond to it. Meaning what? You are reading the consent. And a similar way, consent is read here. Consent is read here. Then the question is, if a consent is read there, whether individual should be an injured party. Not necessary in case of obligation erga omnes. Because the standard is that it is, the injury that is caused to the community, to which you are also a party. That is what the meaning of the erga omnes obligation. And in the Genocide Convention is not with erga omnes obligation, it is erga omnes obligation, erga omnes parte. That means, you are already agreed under a kind of a treaty setting that you are party to this. Therefore, it is common interest, it is a common interest of compliance, any party can take the matter. So this has been done in that way. Now, another important thing here is, one area it is silent, because now they are talking about the right from the Barcelona Traction to the South Africa and Israel. It is only about the multilateral treaties that are taken into consideration. The reason is, generally, whenever litigation goes, it is only the bilateral relationships which are all completely taken before the court, not on the basis of a multilateral, the agreements, where they have accepted something. Now they say that this is a serious matter because the human rights is involved in that. Sometimes environment would be involved in that. If that is the case, it has to be looked into very carefully, because you have to comply with the common interest. When you have agreed under the convention, the multilateral convention, or a treaty, and it is very difficult that you can escape the jurisdiction. The second important point you have to see that all the cases referred to, these are only the issue of a provisional order. Because it is not in a final, because they are not getting into the substantive aspect of law. Whether the prima facie case is there or not, most of the cases it is like that. So it is a kind of a provisional order at that time. When they go to the merit phase, they have changed it also. Say for example, in Southwest Africa case, the merit phase they have changed. Originally it was 7:6. In the merit phase it was 6:6. So this is the status. And I would like to draw your attention, also the audience attention. As far as the customary international law is concerned, there is no clarity on that. If you say that whatever the treaty provision, this is only a restatement of customary international law, it is okay. If it is just a customary international law, then they would try to find out, was there a dispute? This is what happened in Marshall Islands case. They say that the law is violated. Where is the dispute? There is no dispute. And it has been again raised here with regard to the Israeli case now. If it is a dispute, it should be the other party. The other party has not appeared at all before the court. So what we found on this is that traditionally it is even a treaty that needs to be there in place, or agreement needs to be in place between the parties for the settlement of dispute. These are all started with a very famous treaty in the year of establishment of, my friend was telling about BCA, 1907, there was a treaty that is called the J Treaty. That inaugurated really the dispute settlement through arbitration at a particular point of time. So, without agreement, it is not possible. Now, what court is trying to do is, in certain cases, where it is obligation erga omnes, where one party can always, compel the other party to perform the act on the basis of their compliance with the common interest. Now, to my mind, it is not the full door is open to the court. It's just a jar open. We are not sure whether it will be open or it will be shut. Thank you.
Dr. G.V. Rao.
Good evening, everyone. President Parex, Secretary General, Ganguly sir, Dr. Gandhi, all of you here. Like Ganguly sir said, that this is an interesting definition to the, the whole procedure before the court, calling it public interest litigation. Just to give you a brief background, I think India should take the credit for the coining of the word public interest litigation. Actually, in reality, the public interest litigation was first enunciated in the 80s at the time of Justice Bhagwan and Krishna here, Justice Krishna here in India. And in various matters dealing with bonded labor, dealing with workers' issues, etc. Because they were concerned with large number of people. And that's how the word came to be coined. And I happened to have been sent to as a commissioner in one public interest litigation case to go and examine bonded labor in some part of the state of Uttar Pradesh where it was taking place. So I think, and this is also has a kind of a relative concept in the American system where it is called class action suit. So these concepts, if you see the statute, it says that the court shall have jurisdiction between parties to the statute or the UN Charter. So therefore, traveling from there to coming into taking up this issue as recent as in the South Africa versus Israel case with respect to gender, it has had a little bit of a checkered history. The first, as Dr. Gandhi also pointed out, was the Southwest Asia Africa case, way back in the 60s, where they approached the court for certain measures against a neighboring territory. But there, the question of using it as as public interest and class action did not work out, and the jurisdiction was actually denied. Thereafter, again, as the Barcelona traction judgment of 1970, there were partial, first time in 1970, there was a sort of a partial, approach to the court where it looked at shareholders in a different territory and their compensation claims with regards to the damage they had suffered in another territory was partially allowed. That's just the footnote. Subsequently, in 2009, Belgium versus Senegal, which is also again referred to, where the president of Chad was given refuge in the state of Senegal, and Belgium approached the court saying that the president of Chad who had committed violated torture and genocide conventions, etc., should not be allowed to leave the territory of Senegal. And the court made a limited movement towards dealing with a country like Belgium, which had no standing in the matter, except that it was considered that somebody who had perpetrated such violent crimes should not be allowed to go scot-free. Then the Gambia versus Myanmar, where the Rohingyas, protection of Rohingyas, and of course, again, just both Ganguly Sahab and Dr. Gandhi said, and that was Gambia versus Myanmar was as late as 2022, where the court, taking into the consideration of the petition by Gambia, actually passed provisional measures against the Rohingyas, being tortured and even literally genocide being committed. So therefore now that's the journey that has taken place from all the way from the 60s over the years and to the South Africa case in Israel. In these circumstances, what we get to see is the ever expanding jurisdiction of the court, especially when it comes to public causes where large number of people are being affected. They have prima facie looked at not just cases under genocide, they've looked at shareholders being, suffering damage, etc., like in the traction, Barcelona traction case. They have looked at various features and situations and issues which affect public interest. And therefore now that's why we are looking at public interest litigation and the ICJ, and which is very much something that is welcome, that we ought to look forward to its ever-expanding jurisdiction. Given the fact today the world has shrunk, and post-pandemic it has shrunk everywhere. The pandemic itself, it gives, to give you an example, shows how something that could originate in a small town in China could go right around the globe and affect everybody. Also, you would have seen the assistance that was provided so fast by Indian government by providing the vaccines. So both, everything is cross-border, transnational, and simultaneous, real-time. Now, the word real-time was recently sort of coined where when cable television, which some of you maybe not, we saw actually cable television come in the 90s after the Kuwait war, where Iraq invaded Kuwait, and the entire war was live telecast literally by the CNN, and that's what. Now, if there is an earthquake or any fire, anything, we are able to see it simultaneously in today's world. So technologically, what has happened is we have connected in real time with the whole global, and the globalization is literally complete. And institutions now, what does ICJ do? It looks at best practices, it looks at all the other workings of ICC, WTO, all other dispute resolution mechanisms that have evolved, Human Rights Council, etc. It adopts those and multilateral, bilateral treaties, conventions, all of them, all the domain of public international law is applied in situations and disputes before the ICJ. And that is mandated by the statute of the ICJ itself, that the practitioners of international, the academic scholars, conventions, etc., all can be placed before the ICJ when there is a dispute between two countries, or now if anybody challenges an action in another country, for instance, in the South Africa versus Israel case. There, the various interpretations of South Africa coming and knocking at the doors of the ICJ in order to have provisional measures against Israel, and if you see that, I would urge and encourage all of you to go and look at the memorandum. It's a detailed memorandum presented by South Africa regarding every action that had taken place. And only fact of the matter is, South Africa, though it doesn't have a dispute, there was an issue there. One very important issue under the Genocide Convention itself was there a dispute? I mean, did you take it up bilaterally? Did you discuss the matter? So there were exchange of a few emails in less than 1 week or a few days between South Africa and Israel, and the court treated them as insufficient, as not having tried to have a dispute which had emerged to be discussed, or even having some efforts at resolution of that. And Israel, I saw both the days of the hearings of the ICJ. You can still see them; they are all available. That's the greatness of today's world, that you can actually see proceedings in any international forum. And the Israeli council said, we sent a very happy message. We welcomed them writing to us saying that, whatever they wanted to discuss, we were there. There were some holidays, but never a dispute that was sort of discussed or debated between South Africa and Israel in order for it to come before the ICJ. And that is a very important aspect of it, because if you open the jurisdictions of the ICJ, just like what has happened today in public interest litigation in the Supreme Court, what has happened is every Tom, Dick and Harry, including drainage systems, including animal rights, which would not that I disrespect animal rights, but there are matters which could be easily dealt with. And one of the things that the Supreme Court asked, did you take the available recourse to the available methods of resolving that? Did you write to somebody? Did you put the corrector or commissioner on notice? Why have you approached the court straight away? So therefore, the perils of opening the doors of public interest litigation, there are 3 points that I want to make. One is, yes, it's a happy idea to have it opening the doors, but with some reservations, because opening the doors is about opening of Pandora's box. There can be so many disputes that you can keep knocking, and some of that usually done for political benefits and advantages, in order where there may not be a dispute non-existent, or to get some political advantage. Therefore, important thing is, how do we control this approaching of the court by way of public interest litigation without standing even. Standing is the central concept. It's recognized by the statute that it between parties to the charter, first. Second is, how do we filter what can go before the court, and what do we have the present mechanism for that? And the third one which I want to do is, where in the case, for instance, the provisional measures order of the ICJ was sent to the Security Council. I think my good friend Dr. Luther Rajreji would tell me the procedure as to why it was sent to the Security Council and so on and so forth, besides the parties, of course. The fact of the matter is, today peacekeeping and measures which the United Nations system is supposed to take is under complete strain, because the Security Council is under a deadlock, because either of the big powers, the permanent powers so to speak, would block the rest of the Security Council from taking measures in any situation. I'm not talking about the current situation. I'm talking about many other situations, because we've had conflict in Syria, we've had conflict in Iraq, we've had conflict in Iran. You never know when North Korea can do something. You never know what can happen in Taiwan. There are many issues, and there are issues regarding piracy. There are issues regarding environment, huge environmental degradation. There are issues regarding maritime movement. For instance, in Malacca Straits in Malaysia and all that. Now, those issues, if suppose a country like China was to blockade ships from moving about, or Panama was to prevent ships from moving through the canal, there are huge number of issues that could take place. And if there is a judgment of the ICJ where you are actually pinpointing that somebody XYZ is responsible for that, and under international law it's a violation, then you need to have solutions. It can't be a deadlock in the Security Council. There are also issues. Recently, in piracy, Indian the crew was on a ship somewhere near Somalia. We sent our naval forces. Not many countries can afford to do a military or a quasi-military action of saving its assets, maritime assets, or its people. So again, we have to see how the ICJ is able to implement, the ICJ can better implement it. Now, my final point here is, I do see, given the fact that everything changes, in 1945 when the UN Charter came about and the whole post-World War scenario was there were some permanent members, and today with the Brazil coming up, South Africa coming up, that's how we are powerful. India, for instance. India is a living example of a great, powerful nation, which is growing in economic prosperity. It is growing in our global influence with our G20. How do we sort of represent and give, contribute better to a better world order, to a the ICJ statute, which is the very last page, to those who can say Article 69 and 70. There must be some movement to bringing about some amendment to this statute, which will include some of these very pressing questions, especially climate change. January of this year is supposed to be one of the hottest months in I don't know how long. Can anybody tell me, did you read that news item which said that we have the hottest January month worldwide in recent times? Now climate change, Dr. Luther and Reggie is a very good. So these amendments to Article 69, I'll just quickly read so that we can look at it, and these are important and we need to bring about. You know, when we were looking at I was doing a conference in Greece on the law of the sea, and I told a very eminent group of faculty which came from different continents that we must amend the law of the sea, the UNCLOS. And the gentleman said, this is somewhere in 2004 and 5. He said it will take another 50 years. Why should it take? Today in the world, when we move towards real time, when we have technology at our hand, we don't need to physically assemble. We can still work from our respective countries and still bring about amendments to UNCLOS. For instance, Sunil Agarwal, I'm sorry, he's another expert in this thing. So now 16, but the provisions are there. Amendments to the present statute shall be effected by the same procedure as provided by the Charter of the UN for amendments to the Charter, subject, however, to any provisions which the General Assembly, upon recommendation of the Security Council, may adopt concerning the participation of states which are parties to the present statute but not members of the United Nations. It can, the issue of standing or other issues could come under this Article 69 for some amendments to be brought about. So it's time that international law experts of India, as we are being leaders in every other, we must try to bring about amendments to the statute. And again, Article 70 says, the court shall have power to propose such amendments to the present statute as it may deem necessary through written communication to the Secretary General for consideration in conformity with the provisions of Article 69. So even the court could do it. Many times we always talk to our representatives or our judges on this thing and say, no, we need to bring about some kind of change. And I think that's not just the statute of the International Court of Justice, but also the Charter and every other thing where we find that something has become obsolete. Some new developments have taken place. For instance, in the areas of cryptocurrency and etc., they move under the law. There is no law governing them. So thank you very much for this opportunity. I send back to Dr. Narendra Singh.
Thank you. We have heard all our panelists and we have heard their views, and now I open the discussion. Would after that. Yeah, Mr. Jairaj.
Thank you, Mr. Chairman, and I appreciate and grateful to all the panelists who had made very shortly an analysis of the issue relating to the theme today discussion, and it has been really a good occasion to recapture many things about ICJ, the jurisdiction and case laws and all that. So it's a very good experience for me today, at least at this moment. But just as I was listening, I developed a few points. Just when I was listening to all of you. For example, the public interest is always in pursuit of seeking justice. That the ultimate goal is justice, whether it is international setting, because the court is called International Court of Justice. Its Supreme Court of Justice is not there in India, but International Court of Justice, there is something called international justice. It could be between two states, parties, or two organizations and things like that. But here, the justice issue, as evidenced by this third parties taking a position that there has to be a justice on this enlarges the scope of jurisdiction of the court. I would like to ask, or put it to the entire panel, that is there any case in which Dr. Gandhi listed a number of cases. Is there any case in your view that without anybody referring any matter or however most important justice issue involved, the court on its own, what we call technically suo motu, has it taken any issue in the 75 years or not, is one thing that we should consider. Just I'm putting it for debate. It's not a question of, there's no case like that. You can't be rejecting like it because it's a question of curiosity, intellectual curiosity, and rather a question of juristic parameters. Now, it occurs to me, the first, in the modern history after Second World War, the first case of public interest was, I think, in criminal matters, the Nuremberg trial, that took the issues of war crimes. There was a tribunal was constituted, and all of you suggested that taking jurisdiction is to be given by a statute or a treaty, not otherwise. Yeah, whichever way you see, without a standee, you cannot go. But what was the locus standi for taking the issue in Nuremberg, and then what was the law of jurisdiction at that time? I remember those famous words that in the Nuremberg trial, the Nazi accused, they raised that you have no jurisdiction to try me because it's not a crime of that nature. That means that there was no law to indict me today. So how do you take jurisdiction? Then the judges, the court, the tribunal said that we will assume jurisdiction wherever the humanity exists. So it's a question of justice, and humanity-wide justice is to be seen in this context. Why should Gambia or South Africa should be agitated about what is happening in Gaza? Because there is a spirit of international justice, quest for international justice. That should be the main, I think, fulcrum on which the whole debate takes place, here and elsewhere maybe. Now, you see that somebody addressed that is a statute, ICJ statute, is actually virtual repetition of statute of PCIJ. And what was the timing of PCIJ? There was no World War II, it was World War I. At the end, it was part of the Versailles Treaty. But in that, you can see even that the principles of law were practiced by civilized states and all that. It is actually developed, see, it's the ultimate of 19th century jurisprudence. That PCI is statute of 1919. But then in 1949, I think, so this present one was, but it is 45. It's a virtual repetition. So should we, like the Rao took up the issue of amendment. Now, is there any possibility to move from the 19th century basis of this jurisdiction to a wider base for jurisdiction? In the light of Nuremberg and in the light of other criminal tribunals and things like that. Because that is one question I think this forum should explore, how to expand the jurisdiction. Not based on the 19th century, which is reflected even today in the hands of all of us by way of 1945 statute. So that is another thing. I would like to bring to your attention I think these are the three major issues that I want to just put it for you for consideration. We all can discuss this.
Very good thought for every one of us. Yeah. And I compliment you for being here.
There are few points. See, we are we are in our mind comparing ICJ with our domestic courts. In our mind, thinking both parallel. As that court is there, so our courts are there, so that is court. Firstly, a few points. Unlike domestic courts, the ICJ has no power to impede a person, a state. We have in-hand power under Order 1, Rule 10 or otherwise. Every court has in-hand power to impede a party. Impediment of party is connected to enforcement. If any adjudication is done, this boils down to execution. If party is not there or somebody opposes, so it will not proceed. Secondly, ICJ does not sit in benches as we sit. In High Court, one particular bench, PIL. There, all 9 judges or so, they sit together.
15.
15
plus ad hoc judges.
All except from ad hoc.
You are right in saying 9 is the minimum quorum.
And then this 9 will require a consensus to take on such a thing, because they is not part of regular system of ICJ functioning. Such any matter anybody can bring. Theoretically it can bring, suppose it brings. Then what are the options open? Either consensus or another, I think, is such cases, if of interest, international, concerning international peace, security, or general multilateral treaties, then I think court can, ICJ by consensus can convert this case into an advisory opinion. Advisory opinion can be a big area to exploit for rendering such kind of interest, public interest. Then so consensus building will be the developing of international law. If we want to go on that, apart from the functioning small issues. It is all.
Yes, Professor Luther.
Thank you, sir. 3 quick points. One is on jurisdiction. Second is standing, and third is what should have been done in the court has not. It would do it in the preliminary objection stage. I think the first thing is, it's a catchy thing to say, PIL, and most domestic courts have their own concept of public interest litigation. But I think it's, for a student who's listening to this, it's not the best way to present that there is public interest litigation under international. And not before the ICJ, which is a very conservative organization. It's not only is it conservative, but old judges who interpret and apply the law according to the letter, very few times by the spirit. But they are bound, as the principal judicial organ of the United Nations to apply the sources that have been provided under Article 38 1C of this statute. This is one issue. There is what the court has done in the Gambia case and in this case, the South Africa, Israel cases. It has interpreted, Article 9 of the Genocide Convention. It's a compromissory clause to which casts an obligation on all contracting parties to prevent and punish the crime of genocide. So I think when there is an obligation to punish the crime of genocide, the court has not only taken cognizance, but it has felt in both these cases that there is an erga omnes partis standing, which does not tantamount to a public interest. It's basically an interpretation of a treaty. It's, it's bound by a treaty, and the court has, looked at it, looked at the plausibility test, looked at prevention of irreparable harm, looked at, preserving, the status quo in Gaza, and provided provisional measures. So what it has done is, it has done in many earlier cases. It's not done it in the Jadhav case. It's for an academic discussion, it is good to look at what erga omnem partis is. But even this erga omnes partis doctrine, I should say, the court has, rarely touched it. The court has rarely, in very few judgments except Barcelona, where interests of third parties were lying, I think it was bound to do that. But this is the second issue. The third issue which Narendra Singh raised, I think none of you people touched with that. That is a more important issue. That having granted provisional measures, this is a very unique case where, apart from standing, it also is a case where there is a triangular, contest involved, or a triangular situation involved, where the party that brings this particular case is not the affected party itself. So the entire issue of legal injury, not only is it related to claims of a state, but what about counterclaims? What about any form of procedural fairness and justice, where Israel cannot do the same thing and say that excesses have been committed against them? So I think one needs to look at these issues of counterclaims, procedural fairness, which the other party cannot really say, because Palestine has not been implicated as a party. Maybe they would do this in the preliminary objection stage. But it's an interesting concept. I would thank the society for organizing this one.
So just reflect on what you said about the rights of the Palestinians. So that has been reflected also in the court's observations. You find that there is a discussion on that topic as to they are not part of the court, and whether they can bring about a counterclaim or not. I mean, Israel can bring a counterclaim against them or not is an issue they are not prevented. It's only at the interim stage that the matter has gone on because of the urgency of the matter, immediate actions to be taken. Everything is open. The parties have been all ready to come up with their filing of their own pleadings, etc., etc. So that is ongoing thing will go on. So those questions are very important what you raised, but they may come up at a later stage, not now at this point.
So they will come up.
No, if nothing is there, I want to say something. See, the whole thing started, this will explain even that what Luther is trying to do. See, one is the procedure of the court. Second is part of the substantive law. And the substantive law itself confers that kind of a right, that cut across even the procedure. Then should I not claim it? You see, the chapter 3, part 3 of implementation of international responsibility of state. Chapter 1, invocation of the responsibility of a state, article 42. This is a very article that prevents many other states going against the draft article. That perhaps who are working in the L&D division and others, they know about it. State is entitled as an injured state to invoke the responsibility of another state if the obligation breach is owed to A, that state individually, or a group of states including that state, or international community as a whole, and a breach of obligation. When things are very clear from state responsibility, which is a substantive law, when the procedure has not been, properly fitted now, because this is the codification has come later point of time by Crawford, then now how to reconcile this? Now that is what is happening to my understanding.
Just a quick response about the counterclaim. The Israeli defense, they made submissions elaborately dealing with how the provocation was there, how 1,000, almost 300 to 500 of their people, innocent people were killed, massacred in the attack of 7th October, etc. They had given a detailed thing. And that is what led to perhaps not a provisional measures for halting of hostilities. Which is, if you can see that the court seemed to have been quite strict with the Israeli, the action, military action, in recognizing all that has been said about them, but stopped short of pronouncing a provisional measure of halting the hostilities, because that was what was
Not the mandate.
that's what the South Africa case was. The South African case was that they wanted that actually to halt the hostilities.
They did that in the Ukraine-Russia thing.
Yeah, but here because of the fact that it was a provocative action by the Hamas when the whole conflict started, so they did not pronounce.
No,
Thank you.
they were not making a counterclaim. They were actually justifying.
That's not a counterclaim. I'm just telling you a defense.
They were giving
I'm
a
calling it a defense, not a counter, because there's no claim in the asset.
Just, I think, observation. I think this public interest litigation, the name, I saw this title, I was a little amused how to tell PIR in ICJ. It's not possible, as I think some of us recognize this. But definitely, there is a system of, say, this amicus curiae petitions in the WTO, the number of times for upholding compliance with certain agreements, etc. That is possible. And secondly, I think we all know that international law is not doesn't have this concept of precedence, unlike that we have in the domestic system. So even if something like this happens in a particular case, it is not going to have any precedent in the future in that sense. But definitely, from the academic point of view, we all agree that this is a kind of a very good initiative by the court to get into the public, definitely, if not public, the geopolitical issue, let me put it like this. It is not nothing to do with the public interest. It is the geopolitical issues and which concern the state international relations. This is an arena wherein international law is, I think, has to grow more and more, but because international law functions within that geopolitical context, that we have to recognize. I think these are some of the things.
So I just have one observation.
That will be the last question.
Yes. So, sir, thank you for this enlightening lecture. So my one point is that, sir, this public interest litigation is kind of opening the Pandora's box at the level of ICJ, because there are so many cases which are, which can come up in future and which are being, taken to the Court of Justice. Though Gambia versus Myanmar was a welcome change and court accepted that, okay, Arga's obligation was there, and so was reiterated in the case of South Africa versus Israel. But shouldn't we be focusing more on the compliance mechanism of ICJ orders, provisional measures? Because at the end of it, everything goes to, square back to the same thing, like, even if the South Africa's request was entertained and the judgment order came slightly tilted towards the South Africa, but what will happen at the level of compliance? When it goes to UNSC, US being a member and we all know it's little pull towards the Israel side, so we will come and most probably the order will be going in vain. That is what happened in Nicaragua case as well. So that is my point, that what is the use of public interest litigation
being brought up at the level of International Court of Justice, it's just open the Pandora's box only, or it's, as we say, can of worms have been opened. It's going to take more and more time of the ICJ judges and utilizing more and more resources. But we should be, I mean, every international law should be focusing about the compliance mechanism rather than discussing about public interest litigation is what I suggest. And I the ISI that we should be having one special lecture on the compliance mechanism also. We can discuss the cases or like since beginning, Nicaragua and all the other cases. That would be very benefiting to the students and the audience. Thank you.
I will take, sir, half a minute with your permission. The ICJ's order and its decision, how far it is amiably adopted by the disputing countries to make a solution, or it can be enforced by the Security Council in the present big cases in between Russia and Ukraine, Israel and Gaza. Thank you.
Yeah. Shri A.K. Ganguly ji, Mr. Professor Gandhi, Dr. G.V. Rao, Shri Narendra Singh, they all have spoken very nicely and they have mentioned a lot. Now, I am very happy that each one of all of you have heard very well. Now, the public interest litigation in ICJ is what we are discussing, but we really don't need to know at all, because public interest in litigation done in India is excellent, perhaps one of the best in the world, and that is going on for a very, very long time. Both Supreme Court and High Courts have used this public interest litigation extremely well. There are many matters where individuals cannot go, or they will not have interest to go, or they will not have amounts of money, etc. But when something is not for A versus B, but when something which is to be done for a large number of people, etc., then our public interest litigation has been done both by Supreme Court and High Courts from time to time. But of course, now we are talking of what is happening in abroad, as to in the international. It is to ICJ in its implementation of international procedural law has historically remained largely party-oriented and directed at preservation of individual interests. Even when matters were of those concerned to the international community, only the injured parties, those who had rights, had been harmed or were adversely affected, were allowed to do so. The rare cases of public interest litigation, judicial action in support of causes which has not been found any effective recognition or recourses in the political processes. Now that is in the southwest of Africa, in judgment is in 1966 is what it says, that you cannot have public interest litigation. Then the applicants in their fight against racism did not act out of self-interest alone, but were driven by a much deeper desire to fight for the community and their rights, which is what makes PIL an honorable feat. Yet the court let them again, stating that the international law does not recognize an actio popularis, and there is no right resident in any member of a community to take legal action in vindication of a public interest. The judgment faced severe backlash, with the minority stating that it is precisely the role of the court as the principal judicial organ of the UN no step in and advance the general interest in the face of political failure. Now, this was changed, is slow, but has been a long time coming. Notice first in Barcelona, Trecon in 1972, where the ICJ embraced the notion of erga omnes obligations. In addressing 1966 decision, it is referred to situation where a serious breach of preemptory norms of international law justifies any state in invoking responsibility of the guilty state. In Wilgam's case against Senegal in 2012, the court exclusively relied on the erga omnes obligations to procedure or extradite, torture, suspects, and use it was established by the international law. One of the third good important matters was in 2023 in the case of Zambia versus Myanmar, where in the application of the Convention on the Prevention and Punishment of the Crime of Genocide, that the court finally opened its doors to allow public interest litigation against Then come in the Gambia alleged that Myanmar continuously reached its obligations under the Genocide Convention through its acts against the Rohingya group, including widespread and clearance operations, etc. In addressing the fourth judgment is Myanmar's objection that the Gambia had no special interest since they were not affected by the allegations. The court held that the door has been opened to the standing of any member of the international community for erga omnes or jus violations such as genocide. The court discussed that the states have a common interest and the obligations are owned by a state to all parties, and these responsibilities should be allowed. This humanist and people-centered international law tradition by the judges in so and so are there. There is the case in the case of brought by South Africa against Israel for failing to prevent and prosecute while also committing genocide acts to the Gaza Strip. Israel claimed that the court had no jurisdiction over the case since no dispute existed between the country and South Africa. However, nothing South Africa's invocation of their erga omnes obligations under the Genocide Convention. Many have likened this judgment similar to which the court allowed South Africa jurisdiction in this case. Of course, as far as we are talking of what is outside India, but as far as India is concerned, this is nothing new at all. All our judges, especially the Supreme Court and High Court judges, for a large number of matters, the public interest litigation has been done, and many times many people say that the judges are doing much more. They should not do too much, but the judges have been done too much, and our people are very happy. And therefore, I am very happy. All of you have come, excellent speakers, and of course, excellent audience. And I would like to thank each one of you. Thank you.
Just 1 minute. Yes, you can certainly applaud the president.
The whole team.
Yes. Well, I'd like to thank the president of the society, Mr. Parekh, for his address. I thank all the panelists for the excellent addresses they have given, the issues they have raised, and the manner in which they have discussed those issues. I also thank those who have raised questions from the floor, and I want to very briefly just comment on some of those issues which were raised. On the question of suo motu jurisdiction, as I mentioned, the jurisdiction of the ICJ is based on strict consent. Consent can be manifested in different ways, but the consent is essential. And the court cannot take up matters on its own. It's only the matters which are brought before it, either in cases by a state or by way of advisory opinions which are requested by under the prescribed procedures. Now, the question of international law enforcement, that is a question which arises as a matter which affects the strength of international. Now, we are all aware that we don't have a legislature at the global level which can lay down laws which would then be binding on countries. International law comes from state consent by their ratification, acceptance of treaties and conventions, or through customs over a period of time, which develop over a period of time. But the strength of international law lies in the fact that states consider it is essential for states to exist in a global society. Some rules of law which are widely accepted are essential, and this states recognize, and this is the binding force of international law, the interest of states themselves. Now the ICJ decisions, as the statute says, are binding on the parties. But while the actual decision is for the parties to implement, when the ICJ interprets a convention or a treaty or lays down an interpretation of international law, that has a much greater effect. Those interpretations, those decisions on that particular aspect are cited in every case before the ICJ. For example, when you come to maritime boundaries, both cases will cite all the previous decisions of the ICJ in support of their own arguments. They will interpret them in the way which suits them. So every country recognizes that the declarations of the ICJ in the cases, even though they are not formally binding on them, unlike decisions of the Supreme Court of India which bind all the lower courts, but they are treated as very significant and they are cited all over. Another issue of compliance: can states ignore the decisions of the ICJ? Well, we had the case of the hostages in the US Embassy in Tehran, where the ICJ held that Iran was not in compliance with its obligations regarding privileges and immunities and had failed to provide security. But the same Iran has recently gone to the ICJ again against the US, charging that the US is in violation of provisions of the Treaty of Amity. So even countries who may themselves in one situation not have followed the ICJ decision, they themselves approach the ICJ when they feel that their rights have been violated. So this is the importance of the ICJ. The US did not recognize the ICJ decision in the Nicaragua case, but the US Congress did. They acted on it. And the US also approached the ICJ in the Iran hostages case. So this is the strength of international law.
Yeah, one quick comment, closing comment.
One comment.
Yeah.
I think this is the reply given to the last question, what he has stated now. Winning or losing is not matter, but the doors to be knocked, as long as the door is locked, you have to knock it open, because that is the development of jurisprudence. That was precisely explained to you. International law develops by failure as well as success. It is not a continuum as far as the success is concerned in any other tribunals. Thank you.
One recent decision of the Permanent Court of Arbitration in a Davos case, where we had had a contract with a American company in purchase of spectrum, That the divorce judgment. After the judgment, India was to pay $1 billion or something, but Deva, sorry, Deva.
Antrix versus Deva.
Antrix versus Deva, that's sorry. That judgment, then our aircraft was seized at various airports in as a result of that judgment order.
Canada.
Yeah. So therefore, international law is not that completely, without teeth. You can actually enforce it in some ways, and it is getting enforced in some of these areas. So I guess we must make it more and more where it is fair and just.
So just to add up to your thing, sir, the enforcement has been prevented by India.
I know, we did that. I know that. I know that they closed the company. They closed the company so that the money cannot be received yet. So they did something.
We have to stop here. We can keep this discussion going.
Over tea. Thank you so much, ma'am.
You're all invited for tea in the next room. Yes.
I was